It's Monday, and that means another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about sentencing. Cases that should have gone to the Supreme Court of Canada, but didn't. Nedeljko Mikasinovich was convicted by a jury of assault causing bodily harm. He had originally been charged with aggravated assault, and prior to that had had an original trial for 2 charges, including aggravated assault. In his first trial, the jury couldn't reach a verdict on whether or not he had committed the offense of aggravated assault, and there was a hung jury, and a new trial on that charge was ordered. Because he was acquitted on the first charge and ultimately convicted of a lesser-included offense, sentencing became a very complicated process. Mr. Mikasinovich argued at his sentencing hearing that he should not be sentenced for the offense for which he was acquitted, nor should he be sentenced for the consequences of an aggravated assault since he was convicted only of a lesser-included offense. He was given a very significant prison term and appealed his sentence, arguing that the judge had effectively, in his comments, sentenced him for the offenses for which he'd been acquitted and not the one that he'd been found guilty for. Mr. Mikasinovich sought leave to the Supreme Court of Canada, arguing that sentencing judges should not be able to take into account the things for which he had been acquitted. Now, while the Court of Appeal disagreed that the sentencing judge had done that, this case does raise important issues about what happens in these complicated cases where there are multiple trials, very different evidence led, and different conclusions reached by different triers of fact. How does that impact the sentencing process? And what role do the consequences of somebody's actions, even if they don't rise to the level of aggravated assault, play a role in the sentencing determination for an assault causing bodily harm? And where is the line, specifically, between sentencing somebody because of the consequences of their actions and effectively sentencing them for a different offense altogether? These were the issues that were raised by Mr. Mikasinovich's case, and unfortunately the Supreme Court of Canada, I don't think, saw the nuance that was present here, and the nuance that affects so many people who are agreeing to plead guilty to lesser charges every day, or who are found guilty of lesser charges every day by judges throughout this country. Clearly identifying the sentencing principles that play up in those types of cases would have been something that could have had a broad impact on sentencing cases throughout this country and helped defense lawyers, accused individuals, Crown Counsel, and judges alike. The Supreme Court of Canada will have to wait another day to talk about the role that the consequences of somebody's actions play when there is a conviction for a lesser included offense, but the consequences relate to the greater offense for which they've been acquitted. Unfortunately, this isn't going to be the case. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and please like, subscribe, and share with your friends.